Good afternoon, Arratsaldeon, buenas tardes. It's a pleasure for me to welcome you all today on the occasion of the presentation of the book Banking Bailout Law, a comparative study of the USA, UK, and the European Union by the author Virág Blazsek. In the midst of this terrible pandemic, we want to continue in our law school with our goal of promoting the exchange of thoughts that stimulate us intellectually and make us think of a better world in legal terms. We have thought that it will be a great idea to have a meeting online with an attorney of the United Nations who have just published an interesting book dealing with bailout law in a comparative way. Addressing the most current issues of international activity in the financial field can be a magnificent opportunity to gather you all who have found the time to join this webinar, LLM students, international law students, and some scholars of our school. Virág Blazsek is now in New York. Hello, Virág. And thank you very much for accepting this invitation. Let me say that I had the chance to meet Virág Blazsek some years ago. It was in Torino, Italy, with the occasion of the annual event of the international network, the so-called Common Core of European Private Law, a very special long-term project which, since more than 20 years ago, linked together academics and legal actors to research on common legal roots of different legal systems about property rights, contracts, and torts, among other private law issues. Since then, we have been in contact from time to time by email and 2 years ago in Washington, D.C. I'm very happy to have the opportunity to invite you in Deusto. Let me say some words about our guest. Virág Blazsek earned her first law degree from the Eötvös Loránd University, Budapest, Hungary, in 2005. As an Erasmus scholarship recipient, Virág also studied Spanish commercial law, European Union law, and public international law at the University of Girona, Spain, for 2 semesters. She practiced business, corporate, commercial, and insolvency law for a decade at law firms, and for 7 years at OTP Bank, a market-leading Hungarian bank with subsidiaries in 12 Central and Eastern European countries. In 2014, she returned to academia full-time to complete her doctoral studies at Central European University, a career shift very interesting. In 2016, she served as a visiting researcher at Fordham University School of Law in New York. And the next year, she was a visiting scholar at Columbia Law School for 6 months. She defended her dissertation in 2018, 2 years ago. And the book Virág is presenting for us today is based on her dissertation. Virág also completed an LLM Business and Financial Law at the George Washington University in Washington, D.C. And she also served as a teaching fellow and taught banking and antitrust subjects at Budapest Business School in Hungary. Currently, she's a New York City-based banking and finance attorney. Her main areas of professional and scholarly interest include financial stability-related legal, regulatory, and compliance, and other policy issues. And something else, Virág is fluent in Spanish. Dear Virág, we would like you were here in Deusto. You know that I appreciate you very much, and I hope that you can come someday. You are doing a great professional career, and I congratulate for it. It will be an honor for us to have a fruitful dialogue about an issue such interesting as that of your book. Thank you very much for your time and for your generosity. And now I give the floor to Julia Suderow. She is part of our law school. CTT's international commercial law, and she is also a lawyer and a specialist in compliance. She will conduct this event today. Thank you very much.
Thank you very much, Gemma. Thank you very much, Virág, for being today with us. Thank you, Gemma, for this amazing introduction to Virág. I just have to add that congratulations for your career and for jumping always from the academic to the practical part and then back to the academics and then going back to the practical part. This is something that I really like and that I really think that enriches a lot the work that can be done on both sides of the floor, so to say, and it's also can be seen in the book that you're presenting today, which is a great result of the work that you have been carrying out over the last years. I think the topic that you are dealing with is of utmost complexity, and I think it's a great achievement for all lawyers, being on the practical side or being on the academic side, to have a book like this that puts lots of ideas together and makes a comparative approach of something so important like banking bailout law. The problem, in my view, or when we all were overwhelmed by the financial crisis of the year 2008, at least lawyers or people from the academia or people from the legal world, that the uncertainty that we were facing, and works like yours help a lot to reduce this uncertainty, and they also will help us, as you also conclude in your work, to achieve a better system with a better overview. We were just discussing on the way here, Felipe and I, that banking law is such a complex issue that at the end it's very easy to not to have the overview, and particularly it's very easy to lose this overview on an international level. So works like yours are particularly helpful in order to bring the most important things into one source and to make a comparative approach. And for that, it will be very interesting to listen today to your presentation, and we hope we can have a few questions and a dialogue. So after your presentation, if you agree, we will make a few questions. Thank you very much, and the floor is yours. Thank you.
Thank you so much for this generous introduction. It's such an honor to present my book at Deusto. I'm going to share my screen now, and I'm going to right away start this presentation. As mentioned in the introduction, this book is based on my defended doctoral dissertation, and I finalized my manuscript while in Washington, D.C. In 2019, and the book was published last October. And today I'm going to give you an overview of the content of the book. A couple of months ago, I also published a book overview on Columbia Law School's Blue Sky blog. So if you are interested in the topic, you are welcome to read that brief summary as well. So I started my doctoral research in 2014, and the starting problem issue I noticed was the striking difference between the outcome of the US versus European crisis management measures. The chart you see on the screen is the Troubled Asset Relief Program's tracker, which is available on the US Treasury's website. And you can see on this chart that by 2010, more than 50% of the money spent on bailouts was actually repaid, and with interest to the US government. And by 2014, the entire money was repaid. And on the bottom right corner, you can see that the percent recovered is over 100%, more than 112%. I would like to call your attention that this is only about the bank bailout expenditures. You can see that there are different sections for AIG, the automobile industry bailout, and so on. But when you check those segments of the bailout measures outside of the financial sector, you can see similar results, that actually the US federal government recovered the money spent on bank bailouts and with interest. Today, again, I'm only talking about the financial sector related measures. By sharp contrast, the EU's post-2008 crisis response led to a sovereign debt crisis by 2011 in several member states. And I argue in the book that that contributed to the present political tensions within the EU as well. So what happened with the bailout measures has far-reaching effects beyond the financial sector. So this was the starting issue. And I have to admit that at the beginning, I had a very strong anti-bailout sentiment, and I wanted to write my dissertation about why not to bail out banks, because that was the general sentiment on both sides of the Atlantic at the time. And I believe that capitalist market economies have generated a lot of wealth, even if they are imperfect systems. So obviously bank bailouts represent a protectionist and many times politically motivated measure, and they are very debated. However, at an early stage of my research, I realized that there are two fundamental assumptions I needed to accept. One of them is that financial crises are unavoidable, because in the past 8 centuries, and there is a well-established literature about that, financial crises occur from time to time. And the other thing is that bank bailouts are also unavoidable. And there is a very interesting article of Adam Levitin of Georgetown Law School, and basically his argument is that bailouts are mostly politically motivated. Many times the regulator tries to save jobs or avoid the effects, possible harmful effects on the real economy. So when we save the banks, when we intervene in the financial sector, we want to prevent harmful effects on the real economy, which directly affect the life of the people. Therefore, I rather focused in my dissertation and in this book on what went wrong with the European bank bailouts and how to bail out banks efficiently. So bank bailouts are something undesirable, but unavoidable. Therefore, let's take a look at how to do it well. And for that, I had to take a look at the pros and the cons of the different legal and regulatory options, and of course the cases. Now let me stop for a moment because I would like to share with you the only theory we've had prior to the 2008 crisis regarding the bailout measures of central banks. It's called the budget dictum, and it's basically an observation in the 19th century in England regarding the policies of the so-called lender of last resort policies of the Bank of England. And according to this observation, in a financial panic, the central bank's intervention is efficient if the intervention happens early, freely, so the intervention is generous with big cash layouts at a penalty rate. So there is an interest rate that needs to be paid for the central bank against good collateral and to solvent firms. So I observed that the theory is incomplete because beyond these guidelines, there wasn't really any other guideline how to do the bailouts. And that was true on both sides of the Atlantic. As I already mentioned, the bank bailouts have a very ambivalent nature, and even if they are unavoidable and undesirable, it's important to do them in an economically efficient manner. And this book aims at providing guidelines for that. The topic is also very relevant because if you take a look at history, there has been a clear shift only from if you observe the crisis events from the beginning of the 20th century towards more bank bailouts historically. So in terms of how much money was spent and the number of rescued banks has been increasing, therefore it's a highly relevant topic. And one other thing I wanted to observe and take into account from the beginning, that law and regulation should not incentivize more risk-taking. So there is a so-called moral hazard issue related to bank bailouts. And I argue in my book that this can be handled efficiently if there isn't a bailout promise towards the financial sector, and probably institutionalization strengthens such promise in the risk-taking, in terms of the risk-taking of the financial sector. So that is a question whether it's enough to have a set of rules and guidelines, or whether you should actually institutionalize, have institutions for future bank bailouts. Those are two different approaches. And I always have to remind myself that the bank bailouts are not about rescuing the banks, but again, they are about stopping the financial panic situation and protecting the real economy and the stability of the financial sector, because the financial sector is a financial intermediary. And another thing I gave a lot of thought of, what should be the guiding principle of bank bailout law and financial crisis management in general. And I identified two fundamental principles. So one of the guiding principles, of course, is protecting the taxpayers' interests. And this has been the main guiding principle of the post-2008 legal regulatory framework globally. And I argue in this book that that is a very important principle in business as usual times. However, in crisis times, when the recovery of investor confidence is very important to get back to normal, maybe it's better to prioritize that instead of taxpayer dollar protection, which is also important again, but rather in business as usual times. So this is a thought which is argued in favor of throughout my book. So basically, the proposition of this book is that in business as usual times, when there is no financial crisis and panic on the markets, the underlying principle of financial law and regulation should be the taxpayer protection. This is when you think of, for example, the Basel criteria, that's the main purpose. So make banks more resilient and make financial stability more robust. However, in financial crisis times, the underlying principle should be rather the investor confidence protection. So the recovery of investor confidence, even if it costs temporarily taxpayer dollars. Why is this issue relevant from the legal regulatory perspective? Because the entire post-2008 crisis management related legal regulatory framework on both sides of the Atlantic is primarily based on the principle of taxpayer money protection. So basically, I argue that partly that's a good underlying principle, but partly it's erroneous. So in terms of the crisis management, we should rather focus on investor confidence. The methodology of the book is comparative. The selected jurisdictions are the US, the EU, the UK, Spain, and Hungary, because in comparative law, the more different jurisdictions you choose, the better results you can get when you compare certain legal institutions. The topic is very interdisciplinary, as mentioned in the introduction as well, both with the legal sciences. So sometimes I had to deal with constitutional law, debt ceiling provisions, sometimes with monetary or fiscal law related laws and regulations, and so on. And also within social sciences. So this topic is very much connected to the finance and economics literature. I had to read a lot in that area as well. One of the things I relied on is a very all-inclusive bank bailout definition. So because of the questions asked, I didn't focus on where the money comes from. So I didn't really focus on whether the measure was a monetary policy or fiscal policy in nature. I rather focused on that the objective of the measure was the rescue of the failing financial institution, and whether it was external and public money. So that is a very, very vague, a very, very extensive and all-inclusive bank bailout definition, which is unusual in the literature. A novelty I introduced in this book is that I set up a success criteria, which consists of 3 elements. And I analyzed the selected cases, bank bailout cases in the selected jurisdictions along these success criteria. Which is whether the money was repaid or not, how long was the time frame of the measure. So the shorter the time frame was, the faster the repayment occurred, the more successful the bank bailout measure is, and whether there was a positive effect specifically on the financial institution and on the financial sector as a whole. So these are the 3 elements of the success criteria of the bank bailout measure. And I tested the selected case studies through the lenses of the already mentioned budget dictum. So again, the elements of the budget dictum is lending early, freely to solvent institutions against good collateral at a penalty rate. And the other novel thing about my theory is that I set up the concept of banking bailout law, and I identify its building blocks. So I define banking bailout law basically as the sum, the totality of provisions which penetrated to numerous areas of law. For example, the constitutional debt ceiling provisions. Those provisions became part, for example, of the Spanish Constitution. Similar legislation occurred also in Hungary. That was an agenda by the European Union, so it happened in several member states. And find bailout related provisions on the area of debt insurance, compensation, even consumer protection frequently references financial stability. And public finances, monetary and fiscal policy. So that I call bailout law. Can you hear me?
Yes, perfectly.
Thank you. The structure of the book consists of 3 parts. Very simply, the first part focuses on the bank bailout case studies, jurisdictions. I selected more or less 3-4 cases in each of these.
We can't hear you now. Virág, we can't hear you now.
Is the connection back now?
Now, yes. Can you continue?
Yes.
Yes.
Great.
So I continue. Okay. So the second part is focused on the current legal regulatory framework in the selected jurisdiction. And the part catalogs the building blocks and the principles of bank bailout law. Because of the time frame of tutation, instead of going into the details of the analyzed bailout cases, I prepared this table to compare the US and the EU cases. So one of the that the reason the root cause of the bank bailouts was fundamentally different in the US versus the EU, because in the US the failing banks had illiquidity issues. So they had enough assets, but the assets were not readily available to pay at the time when the debt becomes mature. In the EU, the final problem of the failing banks was 2011, but also I think also definitely by 2011, most failing banks experienced insolvency, so they didn't have enough assets to pay the obligations. The response was different, very, very different in the US versus the EU, because the US method was fundamentally equity-based, which meant that the US government bought assets, bought the problematic assets from the financial institutions. In the EU, instead of buying assets, basically that was a bond-based method, and this is to the sovereign bonds, and I would say that the European method created even more debt. So I argue that this method choice contributed to the more negative outcomes in the EU as compared to the US. In the US bank bailout cases, the budget dictum was more observed than in the EU. In the US bank bailouts, there was a very strong focus on exit strategy from day one. And there were incentivizing elements. For example, if the money was paid back sooner, the penalty rate, the interest rate was lower. So that was incentivizing, and those details mattered. And I think those contributed why the US banks actually paid back all the bank bailout money and with interest. Contrary, in the EU, there was more nationalization, which create long-term financial burden for the taxpayer. Also, in the US, the crisis response was much faster, much prompter, and the time frame of the cases was shorter as compared to the EU, where the bank bailouts occurred years later. So the crisis started in 2008. In the US, the bailouts occurred 2008-9, and by 10, the bank started to pay back most of the money. Whereas in Europe, the measures started in 2011-12. So for 2-3 years, it was difficult to understand what was going on in terms of the crisis management. There wasn't really a coordinated response. The financial stability recovered much later in Europe, if ever. I estimate it was recovered more or less by 2015, the profitability in the financial sector, but there is a question mark regarding that. There is also less transparency in terms of how much money was actually spent in the EU. In the US, because of the federal measures and the uniform legal framework, there is more transparency in terms of the money, how much was spent and how much was paid back. And it's also available publicly on the internet. I finally mentioned two fundamental differences. One of them is that in the post-2008 framework, in the US, the legislator didn't create an ex-ante insurance which would be similar to the European Stability Mechanism, which is the crisis fund of the EU. So that is a very fundamental difference in terms of the approach. Rather, in the US, there is an ex-post solution for how to recover the expenditures of the Treasury in the next crisis. I have a different slide on that. And I have to recognize that there were favorable external factors in the US and negative or disfavorable factors in the EU, which is beyond the scope of finance law and regulation. So the US dollar's global position that all central banks keep their reserves in US dollar, and the US dollar's role in global commerce gives the Central Bank of the United States, the Federal Reserve, a very strong position and a much bigger play field in terms of monetary financing related interventions. And the other one is that there has been a well-established bank resolution regime in the US since the Great Depression. So there was more practice in terms of the resolution of failing banks. In the EU, there were rather negative factors which made the crisis management more difficult, and we have to recognize that this is not the fault of the legal framework. These were external and not even legal characteristics necessarily. One of them is that the timing of the crisis hit Europe in a very bad moment, because only 4 years earlier, the European Union experienced its biggest expansion, because 10 Eastern and Central European countries joined the EU, which was a very, very expensive project for the EU. This happened only 4 years prior to the 2008 crisis. And the other thing is that the EU's legal regime is fragmented. So from insolvency law to fiscal law, the legal regimes vary from member state to member state. So that made the financial crisis management more complicated. Because of the shortage of time, I'm going to skip the next 2 slides, on which I basically summarize the post-2008 legal regulatory framework, because I already mentioned some elements of it. Basically, in the European Union, the Bank Resolution and Recovery Directive is the main legislative piece which deals with the bank resolution. And in the United States, the 2010 Dodd-Frank Act to sort out the issues related to a future crisis. In this slide, I mentioned 2 examples, 2 cases where the Bank Resolution and Recovery Directive was tested after the 2008 crisis. And these cases highlight the difficulties, the issues related to the Bank Resolution and Recovery Directive in the EU. The Banco Popular case was basically a private bailout in the end. And it occurred in 2017. And it wasn't really a resolution. So there was some reference to the Bank Resolution and Recovery Directive, but basically a private rescuer, Banco Santander, acquired Banco Popular for a very, very, very low price. The shares cost $1, and there are many issues with this case, which are beyond the scope of today's presentation. It highlights several pitfalls of the BRRD. The other one is the case of the Northern Italian bank failures, and that also highlights different issues with the BRRD, because basically the European authorities allowed Italy to bail out those banks, and there wasn't really a bail-in. Partly there was some bail-in, but not fully as it as it is prescribed by the directive. And finally, a few words about the chief findings. In terms of the scholarship, the novelty of the book is basically the all-inclusive bank bailout definition, the success criteria, along which I analyzed the cases, testing the cases through the lenses of the budget dictum, which is also a contribution to the legal literature in this area, and also the creation of the concept of banking bailout law and the identification of its building blocks. And I identified two misconceptions built into the post-2008 laws. So one of them is that bailouts are avoidable, because in fact we already have these mentioned cases as an example that they are not avoidable. And the other one is that the bail-in can be an effective tool in times of crisis. I argue in the book that the bail-in can be a good tool, and the burden sharing is fundamentally a good principle in business as usual, but it's not viable in a financial crisis situation, in a financial panic. So bank bailouts should be done well, and the learning of the past 10 years of the most recent bank bailout cases is that when the measure is prompter and more generous, like in the US, then the real economy suffers less and the economic growth recovers more rapidly. And bank bailouts in business as usual times and bailouts solely serving political purposes, so when there is no systemic instability risk, should not be allowed. It's very important in terms of the bailout measures to have a very clear exit strategy from day one. So everyone should be clear about how the money is intended to be paid back. Nationalization overall increases the probability of future bank bailouts, because the state's budget and the banks are tied together. And this is not even related, this is regardless basically of the economic system. So the theory is incomplete, and I argue in this book overall that while the preventive leg of this area of law has developed well after 2008, however, the crisis management related leg of the banking bailout law should be developed, and the principles and rules should be readily available before the next crisis occurs. So the chief reason for more successful US crisis response was basically the prioritization of recovering investor confidence, and the chief risk I see in terms of the post-2008 legal framework on both sides of the Atlantic is the prioritization of protection of taxpayer money in crisis times. That should be only prioritized in business as usual. And with that, I conclude the presentation, and we will have a fruitful discussion.
Thank you very much for this amazing presentation. It's a very important and very interesting topic, and I personally have learned a lot, and I hope we can now discuss a lot with the audience. And this is why we open on the floor to questions. If no questions are there, I have already, I think, around 5 or 6 questions, but and I would love to have even more, because the topic is very interesting, and we suffered a lot about this issue in Spain. And well, you said it, they're unavoidable. The question is, are we already again in the next crisis? That's maybe it's an interesting question that we can discuss. But first of all, maybe people in the audience that want to make any questions. If yes, please raise your hand or say something. Open your micro and try to say something.
Or they can use the chat.
Yeah, or you can use the chat, whatever you prefer. Well, in the meantime, if you start thinking about the questions, I didn't mention it before, but we have something in common, and this is competition law. And if you see the case of Spain, Spain had, before the financial crisis in the year 2008 and the forthcoming years, the other years that came afterwards, lots of banks, as you know. We had, I don't know, more than 10 big banks, I would say. And now I think we have 3 or 4 left. or even less. And they are about to merge again because of COVID-19 and the current economic situation. It's not very good in Spain, as you probably know. And my question is, did this also happen, for instance, in the US? Could it be related to this bailout solution that we used in Europe? Because one of the ideas was to create bigger banks that were then more sustainable over the time. But if you create bigger banks, the competition is being reduced normally, no? Because you have less players in the field. And now my question is, do you think that in the US they have a similar problem?
Yes, fantastic question. You pointed out probably the most important aspect of the 2008 framework. Yes, market concentration has increased also in the US. Because of the existence of state banks in the US, there are state and federally chartered banks. The banking system is a little bit different here than in Europe. But, so I would say that in Europe, in the member state, the market concentration is stronger than in the US. But yes, in the US, market concentration has increased as well. And I argue in my book that actually the post-2008 legal regulatory framework, specifically in the European Union, has the unintended negative outcome that actually the Bank Resolution and Recovery Directive may lead to even more market concentration. And actually the acquisition of Banco Popular by Banco Santander is an example of that, because it was not realistic that the value of the Banco Popular shares was just $1. If that would have been the situation, Banco Santander wouldn't have kept Banco Popular's operations as a going concern. And if you take a look at the market composition of Spain afterwards, Banco Santander increased its market share as a consequence of that acquisition. So your observation is I totally agree with that. And this is one of the unintended negative consequences in the BRD, I argue in this book.
Yeah, it's on the one hand side, we breach all the state aid rules, okay, because we are helping companies. Maybe we have obviously a reason to help them, and on the other hand side, we promote concentration, and this has now this effect. And while we think about other questions, I was thinking, are part of these conclusions, could we use part of these conclusions now for all the funds that are going to flow now to all types of industries? Because now we have, at least in Europe, after the COVID-19 crisis,
The same in the US.
and you probably have the same in the US, we call it in Europe the next generation funds. And we have already in Spain, lots of companies, they are already trying to look for projects and ideas, how to be part of this funds and how to obtain as much funds as possible. No? And one of the questions will be then afterwards, okay, we are helping the companies, maybe we are helping companies that are actually not as solvent as they should, okay? And so what is going to happen with the market, and could we learn something from the banking bailout crisis of the year 2008 and the result of the regulation? Could we apply some of these learnings also to the future of these funds that are going to flow into all European Union countries? This is one.
Yes, that was the objective of my book, to take a look at the past cases from a 10-year perspective, when we already have the outcome of the cases. And it's clear that specifically regarding Spain, there was a Bank of Spain study, according to which about half of the bank bailout money will never be repaid. It's not possible to repay all the money spent. So that is something that that will be a burden on the Spanish taxpayer, because Spain pays back the funds towards the European Union, but that money needs to be repaid from somewhere, and obviously that will be a burden of the taxpayer. So I wouldn't extend my research results to other sectors of the economy. So the observation I made are specifically related to the financial sector. I think that other sector bailouts, for example, car manufacturers or airlines, they have different characteristics. The financial sector is a financial intermediary, whereas the real economies sectors have very different characteristics. However, I agree with you that in terms of the bank bailout method, specifically the elements I mentioned, that can be considered as a prudent lending practice. So if we consider the bank bailout measure as a temporary lending a helping hand to the failing entity, then it's worth thinking about to have an exit strategy in other sector bailouts, to have maybe a penalty rate, to have those incentivizing elements. It's very counterintuitive, because you think that an entity is failing. Why would you lend at a penalty rate? Why would there be an interest rate? But the observation based on the case studies is that if you have stronger follow-up, and if you have those parts of the transaction in place, then the repayment outcome is much better. Mm-hmm. The European Union's rescue packages, they didn't have a penalty rate. So the European Stability Mechanism, if you take a look at the monies related to the European Stability Mechanism, they don't have these elements in place.
And is this a more complex situation in Europe, or legal framework, caused by our particularities of the European law system, of the European Union law, of our treaties, and of the competences, so on and so forth? Is it because we are trying to merge and to integrate all the banking union? We are trying to reach a banking union, but we are on the way to the banking union. And as you said before, you have several provisions that are penetrated in several areas of the law. This means that you may have a banking union, but as long as you do not have a fiscal union, you will face difficulties. No, is this also? Could this also be a part of a conclusion, or part of the reasons why we have such a result in Europe compared to the US?
I think that the method choices were obviously related, but they could have been better chosen. But definitely the European Union had a much smaller play field in terms of its options. So, for example, the European Central Bank is not allowed to do any monetary financing. The monetary financing was a very significant element of the US crisis management. That was an element, besides the troubled asset relief program, the system-wide bailout program, monetary policy measures of the Federal Reserve were very significant. And in that respect, the unfinished banking union and the prohibition of monetary financing made the work of the European authorities much more complicated. And the list is long. So I think the European Union has done a very good job in terms of the preventive leg of the post-2008 framework. So if you take a look at the bank resolution funds and the European deposit insurance funds, there has been a lot of improvement in terms of coordinating everything on an EU level, but it's unfinished. So the system is planned to be completed by 2024. So hopefully there won't be another crisis in the financial sector before that. But And also the European stability mechanism is a very favorable and good development. But the problem with that is that if there would be systemic bank failures in many member states simultaneously, the fund is not sufficient to manage that. So it can lend a helping hand to 1, 2, 3, 4 member states, depending on the size of the states, but not for a dozen of member states. It's not. It doesn't have that many financial resources. Are some of the issues that can be mentioned. And also, you know, one of the significant elements of the Bank Resolution and Recovery Directive is the bail-in tool. So basically the writing off or conversion of the debt of the failing institution. And the priority of claims and the application of the bail-in tool is totally related to the insolvency regime of each and every member state. So basically, if I want to simplify it, there is the bail-in tool's application in practice varies from member state to member state. If you compare it with the US, it's called the bail-inable assets in the Europe are called MREL. You can look up what the abbreviation stands for. In the US, it's TLAC. That's the bail-inable assets the bank needs to have the total loss absorbing capacity, and that system is uniform in the US because of the federal nature of the bankruptcy law and the legal framework. Other difficulty in the EU. That is another aspect of the fragmentation I mentioned.
Yeah. Do we have any further questions in the floor from the other participants?
Yeah, there is a comment. I see US Bailout General Motors too. Yes. And if you take a look at the top tracker, even in the car manufacturer industry, I was very surprised because 2 years ago the statistics was worse, but 88% of the bailout money was already repaid, and they plan to repay the whole the entire money spent on in that segment of the economy for the car manufacturer bailouts. So they prove that bank bailouts can be done well, even if they are undesirable. There is a way to do it in a way that actually the taxpayer gets back the money.
Yes. Well, Virág, thank you very much for an excellent presentation. And based on your last comment, so the recovery of the money is possible, and in that sense, the US is a leading example. But I'm intrigued about the role of politics, because I'm afraid that at least based in the Spanish case, the politics play a role. In the sense that they don't go and that they don't establish the necessary regulatory framework to make it possible, the recovery. So what's your impression, what's your view about on the role of politics especially in the European example?
Excellent observation. That's another issue with the Bank Resolution and Recovery Directives regime, that it gives an opportunity to a variety of interpretations. And that's not a Spanish specificity, because if you take a look at the Hungarian application of the Bank Resolution and Recovery Directive or the Northern Italian cases, you can see that politics always plays a big role in the European methods. And yeah, these measures should have like standards and guiding principles, and also because of the protection, the rule of law, you know, in long term, that's very important. You know, the predictability mentioned in the introduction as well. Those are very important. So this is an area where the European systems could develop a lot. to have a more predictable system. That would be a good message for the investors, and that would be beneficial, I think, also for the taxpayer in the long term.
And can I make another question? We still have a few minutes, or one minute left. What about consumers? Consumers are suffering a lot the consequences of the banking crisis, at least in Spain, and I'm sure that in other countries as well, at least in the European Union. And we are also facing now in Spain, I don't think it's a consequence of the banking crisis, but it could be related, lots of mass claiming and mass litigation related to banks and financial issues and consumers. And this makes the system even more complex, no? I think. And this is something, yeah, what about this?
Yes. Yes, there are at least three types of three groups of litigations related to the Bankia related measures, and this has a long-term huge expenses. You know, when, so the effects of those legal disputes are far-reaching. The consumer, I define the consumer protection as one of the elements of the forming banking bailout law in the theory summarized in this book. So basically, if the consumer is in a stronger position, that strengthens financial stability in the long term. So that's what it means that consumer protection is a building block of banking bailout law, that actually it makes the system more resilient. So and also because if, for example, the bank's portfolios are of better quality, so the mortgages, so it's a win-win situation if the consumer is in a better situation, because that can have an effect on the bank portfolios, because the consumer can be a debtor, right? Not only a depositor but also the debtor of the bank. So yeah, but in Spain we are kind of running out of time, but basically the Bank Resolution and Recovery Directives provisions were tested already before the entry into force of the BRD, which was January 1st, 2016. A couple of years earlier, the European authorities required Spain to resort to the bail-in and so on. So I always say that basically the BRD's regime was tested in the Spanish European Stability Mechanism related bailout measures. And the outcome of the litigations is still pending, and it's and I'm familiar with the effects of many retail clients, the very negative effects. So I understand your question, and I think it's a very relevant issue.
Yes, and yeah, it's a problem in Spain. We are also seeing now during after March. I think we do not have time, but I think there is a question from Mikel. Mikel, can you make your question, please?
Sure, I switch on the micro. Well, thank you very much for your presentation. And regarding the last comments that you have made, that you have mentioned that Spain was a kind of test for the bail-in directive. It is true, and there was in the memorandum of understanding for the Spanish bailout, there were some clauses about subordinated liability exercises where debt holders had to take losses for sure for these banks to receive capital injections. But in that same memorandum of understanding, they asked banks to stop mis-selling to clients, because retail clients were sold financial instruments that they didn't understand properly and that they were taking a lot of risk with. And I think that at the same time that it was a test, there were some ethical issues that were involved that at first in the test, they were not dealt with properly. I think that in the directive, they sorted out this thing in a much better way for retail investors. But it was not the case in Spain back in 2012.
Excellent comment. Thank you very much for sharing it.
Okay, any other questions in the floor?
Well, but before we finish, Virág, I would like perhaps you to address our LLM students, to tell them something, some guidelines, some advices to push an international legal career based on your successful legal career. What can you tell them?
Yes, so I myself was an LLM student. Actually, I completed more than one LLM program, and what I can tell you that it was life-changing. So I would definitely encourage any practicing lawyer to conduct LLM studies, because when you study law, after a couple of years of law practice, it's a totally different experience than when you earn your first law degree, because you already have a deeper understanding in terms of the role of a lawyer, and you have an expertise already on an area. So you can target more your interest. You can specialize. So it's a wonderful way to get more specialized knowledge. And if you have any questions related to international law practice, I'm going to leave my email address in the chat box, and please feel free to reach out with any questions, and I will be more than happy to share my opinion about any questions you might have.
Okay, thank you very much. There is another question. I know what she's saying. Thank you very much. It's good to know about the LLM. Okay, so thank you very much, Virág, for this amazing time where we learned a lot about something that affects all of us every day, and we hope we can learn from your findings a lot for the future, and that the next crisis is not so hard as the past one. So as we know that we will have another crisis sooner or later, and for that, thank you very much for your time. Thank you so much from the University of Deusto. It's a great honor to be today here with you. And I look forward to have a deeper look into your book.
Thank you so much. Such an honor to be here. It's been my pleasure. Thank you very much for the opportunity.